My name is Lisl Zamora. I'm a staff attorney with Mid-Minnesota Legal Aid. I work with the Senior Law Project. And just as like a little bit of a background about me, I started out as an attorney practicing immigration law for about 7 years, and then I transferred to our Senior Law Project unit at Legal Aid to try to more round out my area of practice and have more areas that I could practice. And so I've been learning a lot since I started about all these areas of law too, as well as other areas that we practice, which I'll go over in a little bit. So just as a general information, today's presentation is just basic information, right? This is not legal advice. If you want legal advice, you should speak specifically with an attorney in private so that it's confidential. And but this is just kind of a general overview of information and also to help you access it on your own if you want to.
Can I ask a question before we get into too far into this?
Sure.
So then it's possible that you might have to go to two different attorneys, one for power of attorney and one for a will? Or can't you get one attorney that does everything?
I mean, some attorneys do both, right? So you just have to ask when you call to make an appointment with an attorney. I don't know a lot of private attorneys that practice estate planning, so I assume that a lot of them do healthcare directives and powers of attorney as well, because it's kind of in the same area. But other attorneys can do powers of attorney and healthcare directives, but not do wills. So, you know, sometimes they do one but not the other. So just as like a little bit of a roadmap for the presentation, I'm going to talk just a little bit about the project that I work with at Legal Aid, and then giving a big picture about planning ahead, and then going specifically into first powers of attorney and then healthcare directives, and then we can go through questions and experiences. A little bit about Legal Aid. We are a free civil legal services organization, so we don't take criminal cases, is basically what that means. But we have different projects and different units that take a plethora of other areas of law. Our main goal is to help vulnerable Minnesotans to be able to access safety, shelter, food, healthcare, education in whatever legal manner that they have. We serve clients who are disabled, older, which means 60 and above, or low income. Or they could be all of the above. We specifically have a goal to do poverty law work. We have different offices throughout Minnesota, and so we work in over 20 counties in Minnesota and in central Minnesota. Legal Aid was founded in 1913, and so we're a very well established organization. We've had over 100 years of service to the community. So specifically, I work with the Senior Law Project, which, as I said, this is the flyer for our specific project, and talks a bit more detailed about what we do. But we serve people who live in Hennepin or Anoka County, are 60 years of age or older. And for us, because who we can serve varies between units at Minnesota Legal Aid because of the grants that we receive, right? And so for us in the Senior Law Project, income doesn't matter. However, we have very limited resources. We're a very small team. And so we try to filter things out based on the biggest need of who we need to help. We have lots of different issues we can help with. Our project is a little bit different than the other units at Legal Aid because we focus on a specific community rather than a specific area of law. And so we'll have people, calling for all these different issues listed, being landlord and tenant issues, public benefits, Social Security, nursing home, assisted living, probate advice, powers of attorney and healthcare directives, what we're talking about today, and even immigration. Like I said, we're a pretty small team, and so we can't directly take on everything. Also because sometimes people call with areas or questions in areas of law that we are not experts in. And so if we know of somebody who's more of an expert in that area of law, we do a lot of referrals to places where we know that they'll get good quality help from. We also do a lot of brief advice on things because we aren't able to take on everything fully to be able to actually represent people, but we can give advice about how to do it, walk people through things, that kind of stuff. And sometimes we do take direct representation as well, depending on what our priorities are for the areas of assistance that people need. If you do need help, you can call our intake line, which is listed there. It's also on our brochure. It's Monday through Friday. If you don't call during those times that it's listed, you can always leave a message and somebody will call you back as well. So, getting into the big picture of things, the main concern that we're going to talk about today is who's going to be able to make financial and medical decisions for you when you are not able to do it yourself. It depends on your own situation, how you want to go through this. These are some of the possible arrangements that you can make, going from the least restrictive options to the most restrictive. Obviously, the least restrictive options would be informal arrangements, just telling your daughter or your son, this is what I want, and that's it. There's obviously benefits and non-benefits to that. And that goes all the way up to getting formal guardianships or conservatorships, which are very restrictive, would be at the point when you've completely lost capacity to be able to make decisions for yourself and need somebody to just be able to do everything for you. The DNRs do not resuscitate, DNIs do not intubate, DNH is, I think, do not hospitalize. POLST is physician-ordered life-sustaining treatment. Basically directives on specific things. I don't want to be resuscitated. I don't want to be intubated. I don't want to be hospitalized. So those would be as like part of your healthcare directive. So what are the differences between the two? Powers of attorney are to help with finances, and healthcare directives are about the person. What is a power of attorney? It's a written permission for somebody to take care of your property and your money matters for you. So the specific powers that you're giving to somebody have to be stated in the power of attorney. So if you want them to only be able to take care of your banking, then you would specify that it's only banking. The person who's giving the power is you, and you're called the principal, and the person who's taking care of things is referred to as the attorney in fact. So if somebody is talking about having a power of attorney, a lot of times it'll be like, oh, my daughter is my attorney in fact, because you've given them the power of attorney to be able to take care of things. So how much power then does the attorney in fact have? And like I said, it depends on how the power of attorney is written. You only are given the powers that are specified within the document. If you only want specific things, then you write out in the power of attorney form what specific things you want them to be able to take care of. When they then do something, so if they pay your bill for you, then it's as if you are paying your bill. When they act, it's on your behalf, and so it's as if you yourself are acting. So because of this, you want to be very careful who you ask to be your power of attorney, because if they do something that you're not in agreement with or that you're not happy with, you've given them that power. And so, like I said, if they do something, it's as if you yourself are doing it, and so trying to undo that is very difficult. They're supposed to only act in your best interest, but like I said, make sure you choose somebody very carefully who you have a lot of trust in. However, they are not a guardian. It is different than a guardianship. When we were back in the other slide, I was talking about the most restrictive to the least restrictive. A guardianship is the most restrictive. So it's powered by the court. You have to go through a court process to get it. It gives them a lot of power over the person to make all the decisions, because it's for somebody who has just completely lost their capacity to be able to make their own decisions for themselves. A power of attorney doesn't take anything away from you. It doesn't take away the ability for you to make your own decisions. It just gives somebody the ability to help you or be able to make those decisions for you if you are unable to do it yourself. You can change it. You can revoke it. You can change it to a different person. So, for example, I mean, this is just kind of a random example. When I was younger, I went and lived in another country for a year. And so while I was gone, I gave my dad a power of attorney, because then he could go to the bank for me. He could, take care of things that came about my student loans, things like that, while I was gone, because I was not going to be able to access it while I was gone. But then when I came back, I took it away. Do you lose the power to act for yourself? No. If you have capacity, you can still act for yourself. You can still make decisions for yourself. It just gives them the power to also act on your behalf. So the purpose of it is to have a support, basically, to have somebody there who can help you if you need it. Now, what if you lose capacity? This is where we're going to talk about the durable powers of attorney. If your power of attorney is written as just a regular power of attorney, if the person, or if you lose capacity, then it's no longer valid, because you have to be able to continuously be in agreement with it. And so if it's just a regular power of attorney and you lose capacity, then it's no longer valid, and they would have to go to the step of probably getting a guardianship if you need something. However, there are also durable powers of attorney, which are basically the same thing as a power of attorney, but they just have this little phrase or something very similar to this within the document that says, this power of attorney shall not be affected by incapacity of the principal, which is basically saying, if I lose capacity, I still want this to be valid. And so that makes it durable, because it will not be affected then if you lose capacity like a regular power of attorney would be. And I keep going back to this, but on the examples in the Law Help Minnesota website, they have an option to check that as well, if you want it to be durable. So who can be your attorney in fact? It can be anybody you want, basically, as long as they are over 18. You can also choose more than one. You can have a successor power of attorney. So you can say, okay, I want my daughter to make decisions, or to be my attorney in fact. But if she's not available, then I want my son to be able to do it. And so you can have a successor one. It doesn't have to be a lawyer. It's just anybody that you trust. Okay, that's the most important thing, is it has, you really want to make sure that it's somebody that you have complete trust in, because it does give them a lot of power. Choose carefully. Make sure that you want somebody who's going to be good with money. This gives them the power to make all these financial decisions for you. And so you want somebody who is not going to just be like, oh, let's spend all your money on a boat. Somebody who will be conscientious and think of you. What are your needs? What are your plans for the future? What do what are your wishes? And so being able to follow that, because they know that this is what you want. Anybody can make their own power of attorney. You just have to be mentally competent, which means that you are of sound mind. So basically that you're able to make your own decisions. You're not having difficulties with that. If there is any sort of question about whether or not you are competent, or somebody who's making one is competent, then you would want to talk to your doctor or your healthcare provider to know, is this okay for me? Will they, will my difficulties, say if you have early onset dementia or something, then you would want to ask your doctor and say, am I at the point where I can still do this, or do I need to take another step? If you are not mentally competent, so if they say, nope, you are not able to make these decisions, then it's too late to make a power of attorney, and a guardianship or a conservatorship would be needed. Being able to write a power of attorney, it has to be written, dated, and signed by you in front of a notary. Notaries can be found pretty much at any bank. So if you are having, you're worried about, oh, I'm not going to be able to find a notary, that's pretty much a guaranteed place that you'll be able to find one. You just don't want to sign it before you get there. It has to be signed in front of the notary so they can notarize your signature. Like I said, I used to practice immigration law, and there was a lot of confusion about what notaries do within that area of practice. So I always point out the only function for the notary is to look at your signature, look at your ID, verify that it's you, and say, yes, this is the person who signed this. And so they're basically verifying your signature. Then when you've written it and you've signed it, then the attorney-in-fact, the person that you've chosen, also signs, but they don't have to do it in front of a notary. So say your daughter lives in a different town, and so she can't come at the same time, you can't sign it at the same time. You can sign it in front of a notary and then send it to her and have her sign it, and that's okay. They're effective immediately after they're signed, and just with the caveat of, what we talked about before, that if you then become incapacitated and it's not a durable power of attorney, then it would no longer be valid. So what are some advantages of it? It's pretty easy. We have templates on the Law Help Minnesota website. You can check boxes, fill in the form, and sign it in front of a notary, and it's valid. It's done. You get to choose the person that you want to have as your attorney-in-fact. So it doesn't have to be something that's, forced on you. You can choose the person. And it's the less restrictive alternative instead of a conservatorship or a guardianship. And most financial entities will know what it is. So if you need your daughter to do something for you at the bank and she's your attorney-in-fact, if she takes that in, they know what it is. They're not going to be arguing with her like, oh, what is that? They all know what a power of attorney is. The disadvantages, kind of like I was stressing before, you want to make sure that you have somebody who you completely trust to be able to be your attorney-in-fact, because they can take advantage of you. Any decision they make, anything they do, is as if you are doing it yourself. And so we have had people call our intake line before saying, I signed a power of attorney for my daughter, and now she's like doing all of these things with my money, and I don't know what to do, and and so if that happens, then you would want to revoke it, which also there's a template for that as well on the Law Help Minnesota website. And so, like I said, just be very, very careful about who you choose and making sure that that's somebody that you have complete trust in. If I keep saying your daughter or your son, it doesn't have to be, right? It could be your neighbor. It could be your spouse. It could be your best friend. It could be anybody, as long as you have that trust in them. Yes. When you have one, then you would want to, and they're going to use it, then, you want to show a copy to your bank, right? If they're going to be doing these for you. But if you're revoking it, you just have to write out this form that says, I'm revoking the power of attorney given to blank, and goes through a little bit more. Like I said, there's a template on the Law Help Minnesota website, and you sign it, and that might have to be notarized too, I can't remember, but then you send a copy. You keep the original, you send a copy to the attorney-in-fact. You don't have to chase them down and hand it to them. You can just put it in the mail, and then it's revoked, right? And so you would take it you want to then send a copy to anywhere that you have had a copy of it, right? So if they've been doing your banking for you, then you want to show it to your bank and say, do not let this person do anything anymore because I've revoked their power of attorney. They no longer have power to make decisions for me. And it's done. Also, another disadvantage is that they're not required to act, right? This is not something that's court supervised. They're not required to act on your behalf. They're supposed to, but it's not a requirement under the law. And so if they're just saying, no, I'm not going to do anything about it, then you can't force them to. So some safeguards you can take, though, as a process of when you have a power of attorney is requiring regular accounting. You can have a third party look at these as well. It doesn't have to say oh, I need you to give me statements of this and this and this. You could have if you have an accountant or something, you could ask that they make sure that they're regularly giving an accounting to your accountant. You can put more than one person as your power of attorney. So you could require that 2 people work together to do this, to make sure that they are in agreement or, doing what is in your best interests. You can also do it as a professional fiduciary, right? It doesn't have to be, most people choose somebody they know because they trust them, and it's somebody that they have a lot of trust in, and want somebody who knows them to be able to make these decisions. But you could do it with assign a professional as well. So do you have to make a power of attorney? Is it a requirement as you get older? No. Nobody has to have one. But it's just a good idea to think about, at least as you're looking ahead and as you're planning ahead. Like I said, the short form power of attorney and instructions on how to do it are at this website that I have the card for, which I think most people took the card. And as well as the instructions and a sample form of how to revoke it if need be. A lawyer can help customize these. So if you were going to an attorney for, like you said, a will, and you want to also do a power of attorney, you could ask them, like, how much would it be to include that in it, so that you're not worrying about trying to do it yourself or whether or not it's correct or anything like that. Especially if you want to customize it a lot and put really specific things in it, then it's good to consult with a lawyer about it and ask about adding specific clauses to it. So what do you do once you have the power of attorney? You want to keep your own copy. Should have the attorney, in fact, should have a copy, because that's how they can show that they can act on your behalf. You can give copies where it's needed depending on the powers that were given. So, as I said, if they are doing your banking, then you would want to give a copy to your bank. So we've talked about this a little bit already, but how does it end? If you lose capacity and it's not a durable power of attorney, then it's over. It's not valid anymore. You can revoke it in writing, like we were talking about. If you have your spouse as your attorney, in fact, and you get divorced, then that invalidates it. Obviously, if you pass away, then it's no longer valid to have a power of attorney. So obviously you'd want to do different planning for after your death. If you do have a durable power of attorney and you lose capacity, then it can only be ended by a court-appointed conservator. So if you have lost capacity and you have the durable power of attorney and you decided, I don't want this person as my power of attorney anymore, because you're unable to make decisions for yourself, then the only way to end it, you can't do the written revocation. You have to have a court-appointed conservator do it for you. So on to healthcare directives. You, as a disclaimer from the beginning, you have the right to make the decisions about your own healthcare, right? And so you can decide now what you want to have happen to you in specific situations. A healthcare directive helps plan for incapacity by naming a healthcare agent and leaving healthcare instructions. So what is a healthcare directive? It's a document that lets you leave instructions about your healthcare, basically. And so if you get to the point where you can't specify, I want this to happen to me, then you can have written instructions prepared so that, and have somebody who is aware of that and has a copy of it so that they can come in and say on your behalf, no, this is what she wants or he wants. Who can be your agent? It's basically the same as the power of attorney, anybody who's over 18. And with the caveat that it can't be like your doctor or somebody who's working for your doctor. So when you're picking the person who you want to be your healthcare agent, it's the same thing. You want somebody who knows you well, and that you trust will follow your wishes for what you want to have happen to you, somebody who will act in your best interests, and somebody who's going to be available to talk to your healthcare providers, right? So sometimes people have their children as their power of attorney, and then their child moves to England, right? And so they're not going to be available if you are in the hospital and they're trying to make these emergency decisions. They're not going to be available to be able to make your wishes known for your health care. So you'd want somebody else as your healthcare agent that's more immediately available if you're in this situation where they need to have immediate answers about what they should do. So you want to talk to the person that you want as your healthcare agent, because obviously you want to make sure that they're willing to do this, be willing to make these decisions, because they are, honestly, sometimes they're kind of life and death decisions, right? And so that's a lot of pressure on a person, and some people may not feel comfortable making those decisions. So you want to have a conversation with them before appointing them and make sure that they're okay with it and that they're willing to make those decisions on your behalf. And again, think about, do they know your wishes? Are they going to be able to specify, like, this is what she wants, this is what he wants. He specified that he does not want to be intubated. Do not intubate him. And really be able to express and tell them what it is, what your wishes were. Can you have more than one agent? Same thing with the power of attorney. Yes, you can have more than one person. If you have more than one person, you would want to say that either you want the agents to decide things together, or it could be like an either or. Like, you can either contact this person or you can contact this person, but they're both my healthcare agents. Or you can say you have to contact both of them, they have to agree, and they have to make the decision together. It's just whatever you prefer. And then also you can name an alternate agent, right? So you could say first contact this person, but if they are not available or you cannot get a hold of them, then you can also contact this person as an alternative. When do they take over decisions? So that would be when your doctor or the healthcare provider thinks that you cannot make your own decisions. Or you can specify it in your healthcare directive. You can say, I want them to take over at this point, and have it, laid out there. So remember that, this is your person's voice for you when you can't speak. And so you want to, again, I know I've been stressing this a lot, but make sure it's somebody that you trust that will make decisions on your behalf and follow what it is that you've told them you want. They would then make these decisions as if they were you. Right? And so they should be really conscious of what it is that you specifically would want in that situation. So it is very important. It's very important in both situations, powers of attorney and healthcare directives, but you definitely want to have very clear communication between you of what exactly it is that you want. It's just the healthcare directives, I guess, is a little bit more, just because when it gets to the situation that they will be making these decisions, it's because you cannot. And so, whereas a power of attorney, you can give somebody to act at the same time as you can act, and so you can be having a conversation while they're doing it. Whereas the healthcare directives, by the time they're making the decision, you're not able to voice your opinion. And so you want to make sure that they know it beforehand. Again, the same thing as with the power of attorney, they're not legally obligated to act, right? So you can name an agent, but you want to make sure that it's somebody that you trust that will actually act if in this situation, because they aren't forced to. It's just they're supposed to, but it's not a legal obligation. It's not something that is, supervised by the court, that they're doing what they're supposed to do, kind of thing. So what are the requirements for writing a healthcare directive? It has to be in writing. It has to be dated and state what your name is. It has to be signed, again, in front of a notary, or it can be witnessed by two people. So this one has an alternative. If you can't find a notary, which honestly, like I said, you can pretty much find a notary at any bank, so you should be able to find a notary. But for example, like during COVID and banks were closed, right? You couldn't get in person, and it was really difficult to find a notary to be able to sign stuff. But You could, for a healthcare directive, then in the alternative, have 2 people witness your signature instead. However, one of the witnesses cannot be the person that you're assigning as your agent. It has to be 2 separate people. It then has to include you naming somebody as your agent that you want to make these decisions for you, and can give specific healthcare instructions too. So it can specify what it is you want. Or it can just say, this is my agent, and then you can have a conversation with that person and specify what you want. Or you can do both, right? You can say, this is who I want as my agent, and this is exactly what I want in the document. To be able to sign it and have it be valid, again, you have to have capacity first. If you're incapacitated at that point, then you would need a guardianship. So there's a suggested language for what should be included in a healthcare directive in the Minnesota statutes. So you could look that up. Or, like I said, Law Help Minnesota has a suggested form as well. And it does allow for customization. So stating like what your limits are, what your preferences are in different areas. But so when they use the healthcare directive form, your agent will automatically be able to make these decisions unless you've limited it specifically within the form, which you can do. They'll be able to consent to or refuse or withdraw medical health care on your behalf. That includes intrusive mental health treatment. So if you are, put into a hospital because of mental health issues and they feel that this is something that you would not have wanted and that it was too intrusive for you, they can withdraw it. They can also stop or start care, which is meant to keep you alive, like specifying the do not resuscitate or do not intubate. They can, not just those, but even, just the life-saving care that people have, in emergencies. If you don't want it, then you can specify it in your healthcare directive. You can say, no, if it's my time, it's my time, and I don't want you to do all these things to me and to my body to try to bring me back, just let me go, And your agent can specify that too and say, like, no, you don't do it. They don't want it. Or in the alternative, if you want everything, you say, do everything possible, I do not want to die, do everything you can to bring me back, then you can specify that too. And again, remember, you can limit their powers, right? So you can limit how much they can decide on your behalf. They also, unless you limit their powers, can choose who your healthcare providers are. So they could choose to move you to a different hospital, or they could choose to change your doctor, or something like that if they don't feel that you're getting the care that you wanted. They can also decide if you live in your home or if you go to hospice or to a nursing home. That's, a pretty big decision too. So it's not just, a lot of people when they think of healthcare directives, they think only of these end-of-life situations, right? Like only like, do I want them to bring me back? Do I want them to do these specific things to me? But it's also like, do I want them to send me to hospice if I'm at the end, or do I want to stay home as long as possible? Do I want to go to a nursing home? And being able to specify that kind of thing too if you get to that point. They can also review your medical records and give your medical records to other people. Caveat, remember that this ends when you pass away, right? So if they're going to need your medical records and you have passed away, a healthcare directive or a power of attorney does not give them the ability to get those. And so you would have to specify something like that in your will instead, or do some other separate planning for after you've passed away if they're possibly going to need access to that. And then obviously, then they can also visit you when you're a patient. They can also make the decision this is like a caveat to like not being able to make decisions after you've passed away, but they can designate whether or not to donate your organs, including like your tissue or your eyes after you die. And then it can also say what you want. They can designate what happens to your body after you die. Do you need a lawyer? Same thing. No, you don't need a lawyer. There is a example form to help you fill one out, or one that you can, fill out yourself on the Law Help Minnesota website. But if you do want to go through a lawyer, they can help give you advice on what may or may not be a good idea, giving guidance on, your specific situation, and helping you be able to customize it more than maybe you can just with the generic form on the website. If you've written one out, you have it all signed, everything's ready, what do you do with it? You want to keep it in a safe place, but not a safety deposit box, right? Because it has to be somewhere where people can access it. And so if you have it as a safety deposit box that only you can access, it's not going to be helpful. So you want to have it somewhere where it's safe, but where they'll still be able to get access to it. Give a copy of it to the person who's named as your agent. If you have an alternate agent, give a copy to them as well. You can, it's a good idea to give a copy to your family then and your close friends, especially to help make sure that, because it gives you the option to either designate an agent or specify exactly what you want to have happen, or both, right? So if you only specify what you want to have happen to you, but don't name an agent, then make sure that you give copies to people so that, your family and friends can kind of be like, no, this is her healthcare directive, this is what you need to follow, kind of thing, and give it to them, the medical providers, at the time that it's needed. And you can give it to your healthcare provider. That might not be the person that's doing it in that situation, if it's an emergency or something like that, but it's good to have your doctor aware of what your wishes are, if you're having it at your clinic, just in case your doctor's not there, right? So you don't want to just give it to only one person. If you are receiving home care services, through a PCA or home health aid, something like that, you can give a copy to the agency so that they're aware as well. Or if you're in hospice, when you get to this point and you write one, then you can give a copy to the hospice so that they're aware of what your wishes are. Can you cancel it? Yes, you can. This is actually easier to cancel than a power of attorney. You can just destroy the original document if you want. You can tell another person to destroy it, right? So if you are, say, in hospice and you don't have access to the original, and you decide, nope, I changed my mind, I don't want to follow what I had put originally, so I ask my friend to go to my house and get it, this is where it is, please destroy it. And that also takes care of it. You can write and date a statement that says you want to cancel all of it or part of it, right? So you can decide, actually, I decided I don't want this one little thing that I included in that. You can write out a statement and say, I changed, you don't have to even say I changed my mind. You can just say, I no longer wish for this, this, and this in my healthcare directive, and sign and date it. You can verbally say that you want to cancel it in front of two people. They have to be it's kind of like the signing, right? It's not just the agent. It has to be two separate witnesses. Or if you just make a new one, that invalidates the old one. So you can just, if you've just changed your mind, you say, you know what, I have a new plan. This is what I want to actually happen. Then you can write that out, sign it, get it notarized, have everything done, and that invalidates your old one. You don't have to worry about that one anymore. All right, well, thank you so much for having us.